Okay, we're now on the record on Monday morning's docket, June 21st, 2021. Happy Monday, everyone. I hope you had a good weekend. For those fathers that are on here, happy belated Father's Day. I hope that they treated you very well yesterday. Yesterday was your day, but only yesterday. No, I'm just joking. So, who do we have here? Who's Alexandra Ruth's attorney? Okay, let me take Miss Thompson up first. Okay, good morning, Miss Thompson. What number are you on the court's docket?
I apologize, Judge. I don't have that.
Okay, what's your client's, it's number 4.
Thank you, Judge. It's F238529.
Okay, and I see that your client is on. Is Mr. Fuentes on?
He is, Your Honor. He's in a black shirt with a white Nike swoosh.
Okay, today we're set for a final hearing. Are we ready to move forward on that?
We are, Your Honor.
Okay, Mr. Fuentes, are you still representing yourself?
Yes, ma'am, I am.
Okay, and is your client able to proceed? I see she's in the hospital.
Yeah. She was adamant she wanted to go forward today, Judge, to get this done. So it's my understanding that she is able to proceed.
Okay, let me go ahead and have both your client and Mr. Fuentes raise their right hand, please. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Aguia?
Yes, that's correct.
Mr. Fuentes?
Yes, ma'am.
Okay, I need you to listen carefully to what Ms. Thompson is going to state, okay?
Yes, ma'am.
Okay, Ms. Thompson, you may proceed.
Judge, we were here for temporary orders on May 26th of this year, and the parties agreed to no access for Mr. Fuentes. He said he was going to obtain a lawyer. We went to mediation. We were not able to reach an agreement at mediation either. This is a case where we are asking for a lifetime protective order. On May 8th, he shot at her approximately 13 times outside of her home in her neighborhood. He was arrested for it, and an emergency protective order was issued. We cannot agree on the issue of visitation. We can't agree on the issue of child support. We can't agree on the issue of medical support either. The child is currently on Medicaid. I think we have an agreement on the property portion of it, though. And if both of you can please listen to the agreement I think you have on the property. Each of you keeps your own bank accounts. Mrs. Aguia, you would keep the 2020 Chevy Trailblazer with the debt. Mr. Fuentes, you would keep the 2018 Dodge Charger with the debt. Each of you keeps any personal property in your possession, and each of you is responsible for any credit card in your name. Is that correct, Mrs. Aguia?
Yes.
Is that correct, Mr. Fuentes?
Yes, ma'am.
Okay. So the remaining issues pertain to the child, Your Honor, who is 1 year old.
Okay. And Mr. Fuentes, the last time that we were here, you had stated that you were going to retain counsel. Have you changed your mind, sir?
Can you repeat the question? Sorry.
The last time that you were before the court, you stated that you wanted to retain counsel, which is an attorney. Have
Yes,
you
ma'am.
changed your mind?
Yes, ma'am. I'm just gonna represent myself.
Okay. Now, you do realize that the charges that are pending against you are very serious charges.
Yes, ma'am.
Okay. And because as long as those charges are looming over you, that makes it very difficult for you to have any access to your child. Do you understand that?
Yes, ma'am.
Okay. Now, with child support, it's very simple. Are you working?
Yes, ma'am.
Okay. Where do you work?
I work for Charter Communications.
Okay. And how much?
Sorry to interrupt, but we had already discussed that. We had already settled for, I believe, $300, or I don't know. Ms. Thompson should have the information on that.
Judge, on the temporary orders, the parties agreed to $303. I just didn't know if it was an agreement today. Is that an agreement today, Mr. Fuentes?
Yes, ma'am.
Okay. And on the medical support, Mr. Fuentes, your wife was going to be providing Medicaid, and you were supposed to be reimbursing the state. Is that correct as well, an agreement?
Yes, but on that one, do they deduct it automatically from when I pay child support, or what? How would that work?
The state, you are required to reimburse the state for the Medicaid coverage. That will
Okay.
be in the child support order so that they also take that money out. That money will not go to Ms. Aguia, it will go to the state.
Okay, yes.
However, that I don't have anyone from the AG's office on right now, but I do know that that number has been fluctuating, Ms. Thompson, so that so I don't know what they're accepting right now. It used to be that the least that they would accept is $50. Okay,
That's what I had understood, Your Honor.
okay. I would just set it then at medical support at $50 to be reimbursed to the state.
Understood, Your Honor. And so, Mr. Fuentes, are we in agreement on visitation that you won't have access either to your daughter?
I mean, I know it's very difficult. I mean, can I have a FaceTime call at any time or something like that?
Okay, FaceTime calls, like I said, I believe you all had that on your temporary orders. And how did that work out?
We had one FaceTime call, Your Honor, and Mr. Fuentes didn't call in. He called my office saying he didn't know who to call. So the FaceTime didn't happen, but we're okay
Yes.
with a once a month FaceTime call.
Okay, it's not once a month, probably, I'm not saying every day because children don't even stay that long, but I would say at least once a week.
Got it.
And like I said the last time, do not be asking any questions as far as like, show me where you are, show me your surroundings, what is mommy doing? None of those things. Who is mommy with? Your conversation is just with your child. And it's just going to be a short 5 minutes at the most because it's a 1-year-old. You're not going to be able to keep the attention span that much. Now, the reason that this is happening or that you're facing this is because of your pending charges.
Yes,
Once you find some resolution to those pending charges, then you are always able to ask for a modification because the basis of you not having visitation at this time are those pending charges.
Yes,
So
ma'am.
once those pending charges have been resolved one way or another, then you'll be able to better see how it is that you can proceed with some type of visitation. Now, Ms. Thompson will not be able to tell you how to modify that. So you're not to call Ms. Thompson's office to ask her, now can I do it? How do I do it? That's going to be up to you to find counsel, or if you choose to do it on your own. Okay?
Yes, ma'am. I understand.
But I will tell you that as long as those charges are pending at this point, those are very serious.
Yes,
So
ma'am.
nothing will be resolved with visitation until that's taken care of.
I understand.
And your weekly FaceTime calls, that needs to have a designated date, day, and time.
Definitely. I can work with whatever Miss Aguia has to say.
Okay. So Ms. Thompson will get with Ms. Aguia to see what date works best. And for now, we will go ahead and does he have access to Ms. Aguia's telephone number at this point?
Ms. Aguia, does Mr. Fuentes have your telephone number?
Yes.
Okay.
Okay. At this time, we'll go ahead and use her phone number. Now, if it becomes troublesome, I would have a backup plan as to what other number to call.
Yes, Judge. We'll go ahead and put down her mother's phone as well.
Okay, just as long as she has access to FaceTime.
Yes, Judge. And Judge, we'd ask you to take judicial notice of the pleadings on file and to go ahead and approve the parties' agreement regarding all the other issues and pronounce the parties divorced.
Okay, so Ms. Aguia, do you want to go ahead and ask her the foundation of the of the questions. I know she's in an
Yes.
uncomfortable situation, but
I will do so, Judge. Ms. Aguilar, have you resided in the state of Texas 6 months prior to filing for divorce?
What does that mean?
Did you live in Texas for 6 months before you filed for divorce?
Yes.
And did you live in Hidalgo County for at least 90 days before you filed for divorce?
Yes.
And your husband is Alex Fuentes, correct?
Yes.
And you're asking the court for a divorce today?
Yes.
Your daughter's name is Aliana Fuentes?
Elena Fuentes.
Elena Fuentes?
Yes.
And the agreement of the parties is each own bank accounts. You keep your car with your debt. He keeps his car with his debt. Anything you have, you keep. Anything he has, he keeps. You all pay your own credit card debt, that whatever debt you all have. You're going to keep providing Medicaid. He's going to pay back the state $50. Y'all have agreed for $303 in child support and the sole managing conservatorship as well. The court has ordered FaceTime access of once a week. Mr. Fuentes is only to communicate with your daughter for 5 minutes. We will provide a day and time in the order, and he'll be calling your phone or your mother's phone. Do you understand that?
Yes.
Mr. Fuentes, have you heard the agreement and the portion of the court's ruling?
Yes, ma'am.
Is that all you're understanding as well?
Yes, ma'am.
And you did indicate that you wanted to proceed today without an attorney. Is that correct?
Yeah, that's correct, ma'am.
Okay. Is there anything about this that you feel is not fair or is unjust or not in your daughter's best interest?
No, ma'am.
Everything is okay?
Yes, ma'am.
Okay. That's all we have, Your Honor.
okay. The court will take judicial notice of all the documents in the court's file and approve the parties' agreement as testified to in the record, and that will be set forth in further detail in a divorce decree to be signed by all parties. And Miss Williamson, I'm sorry, I'm looking at Lucy Williamson in the waiting room. Miss Thompson, how much time do you submit that decree?
About a week, Your Honor.
Okay, so I'll go ahead and just have a tickler set for July the 9th in case there are any issues to delay the signing. Mr. Fuentes, please stay in contact with Miss Thompson's office
Yes, ma'am.
so that you can also get that signed as soon as possible.
Yes, ma'am.
Okay, Miss Icky, I hope you get to feeling better.
Thank you,
Thank
Judge.
you.
Okay, the parties are excused. Miss Thompson, do you have anything else?
That's all I have, Your Honor. May I be excused as well?
Certainly may.
Thank you. Bye-bye.
Okay. Any quick announcements we signify with a reaction button or any? Yes, Miss Fuentes Aguilar.
Good morning, Your Honor. I have number 12 on the docket, Judge.
Okay, F 3136 139 in the interest of Delilah De Leon.
Yes, Your Honor, and I'm set for a motion to withdraw, and I believe Ms. Williamson is set on a motion to enter.
Okay.
It looks like she's not connected.
Yeah. Miss Williamson, well, I guess if she's not connected, she's not going to hear me.
I sent her a message, but
Do you want to try calling her so she can look at her screen to turn on the audio?
I can, Judge. She did just put that she's not objecting, but let me see if she can get on. Well, Judge, in the meantime, I don't know if my client is on. Okay. Ms.
Sorry,
Williamson is not on.
I am sorry, Your Honor. I want to thank Diana for letting me know I wasn't completely on.
Okay, let me call F 3136-13-9 in the interest of Delilah De Leon. And what are your announcements, Counselor?
Good morning, Your Honor. Diana Fuentes Aguilar on behalf of Elva Verial.
Your Honor, good morning. Lucy Williamson here for Adolfo De Leon.
Judge, and I've got a setting for a motion to withdraw as Ms. Verial's attorney.
Okay, and I don't know that she's present. And is Elva Villarreal present? Okay, and you gave her notice of your motion, correct?
Yes, Your Honor.
Okay, and so any opposition, Ms. Williamson, of Ms. Fuentes Aguilar's withdrawal?
No, Your Honor.
Okay, then that'll be granted.
Thank
And
you,
Ms.
Your Honor.
Williamson, you have a motion to sign temporary orders?
Yes, Your Honor, I do.
Okay, Ms. Fuentes Aguilar, I did grant your motion. You can stay on or you can get off.
I'm going to leave, Judge. Thank you. I appreciate it.
Okay, Ms. Williamson, you can proceed.
Thank you, Your Honor. My client was on. Your Honor, we're asking for the court to sign the order. It reflects what was read onto the record back in, we had a hearing March 31st. All the terms are as read into the record.
Okay. And well, the Ms. Villarreal isn't on so that she can, whether she opposes or agrees, but I'll go ahead and have that forwarded to my queue and I'll grant your motion to enter.
Thank you, Your Honor. We have provided the order to the court.
Okay, I'll request that. Anything else?
Not on this case, Your Honor. I have a couple more cases in your court.
Okay, and so once those temporary orders are entered, how much time do you think you'll need before you can finalize it? I know that's hard now.
Yeah, with her, but I would ask for 30 to 45 days to give us time to give her notice, adequate notice.
Okay. Why don't we do, I misplaced my reset dates for something. Hold on. Here they are. Okay. Let me see. Why don't we come back on July the 26th? And we'll go ahead and put it for a final. And if not, we can at least have a status.
Yes, Your Honor. Thank you.
Okay, so that'll be July 26th at 9:30.
Yes.
And your next case, Ms. Williamson?
Your Honor, I also have F 7172. No. Yes, 15-9.
Okay, in the interest of Gabriel Contreras, that's number 8 on the court's docket. Who do you have as opposing counsel?
Your Honor, I have no opposing counsel on this case. We have temporary orders in this matter already. I represent the mother, Brianna Lupita Medina.
And who is the father?
The father of the child is Antonio Enrique Contreras. And I do see Mr. Contreras on the screen. Your Honor, if I could be given a minute, I think my client is here so I could get her in my office.
Okay.
Good morning, Your Honor.
Good morning, sir.
I apologize, Your Honor. Ms. Medina should be logged in via Zoom, and I'm trying to find her.
Okay,
I'm here.
I
okay,
have her under Zoom user.
okay. Is there an agreement to move forward?
There is not. I know Mr. Contreras is pro se. And we have not, we had a previous mediated settlement for temporary, but do not have one for final.
Okay. So, Mr. Contreras, will you be hiring an attorney for this?
Ma'am, I didn't hear that.
I'm sorry?
Could you repeat that? I didn't hear that.
If you will be hiring an attorney or will you be continuing pro se?
What does that mean, ma'am?
If you will be hiring an attorney or are you going to be continuing to represent yourself?
I was looking to get an attorney, but I'll just go ahead and continue representing myself.
Okay. So, Ms. Williamson, so then you'll need a setting for a contested hearing?
Yes, Your Honor.
Okay.
And it will give us an opportunity to mediate it again if the court requires that.
Okay. Let's see. The earliest I have, let me double check. Ms. Rivera, do we still have the afternoon of August 23rd open?
No, Judge, we don't. We do have the 30th.
Okay. Then we'll do August the 30th. That's the earliest that I have on for a contested setting. And that'll be at 2 o'clock.
Thank you, Your Honor.
Okay. So, Mr. Contreras, I am going to require you to go to mediation prior to final. And if you do hire an attorney, I do suggest that you do that very quickly. And if not, then you need to be prepared to move forward with a contested hearing on August the 30th at 2 p.m., sir.
Okay. What is that? A contested hearing?
Where you will have to, where testimony will be put on the record regarding the issues that are pending. Okay?
Well, what exactly does that mean, ma'am? Like, would that be like closing the case or?
Mr. Contreras, it's because when you represent yourself, I have to treat you like I would an attorney and with that level of courtesy and professionalism. So if you're going to represent yourself, you need to be ready with either you're going to put on testimony, the Miss Medina will be ready to testify. You will have to be ready to testify. If you have questions that you want to ask of her, you need to be ready to ask those questions. You know, you can't just disagree to disagree. If you're going to disagree then and you're representing yourself, then you need to be prepared to move forward as if you were an attorney. And if you don't feel that you can do that, then you need to go hire an attorney. Because I understand that sometimes people don't want to agree because they think they don't have to agree. But you are also required to go to mediation prior to your final hearing. So Ms. Williamson is not your attorney. She is not required to explain anything to you or give you any legal advice. So if you're going to continue to participate in the process on your own, then you need to make sure that you can do it. Okay? So I suggest that you try very hard at mediation. Who did you all mediate temporary orders with, Ms. Williamson?
I apologize, Your Honor. It keeps going back to, I do not recall who we mediated it with, but I would almost automatically say that it was with Edna Cedillo.
Okay. Well, then go ahead and return to her prior to the final hearing.
Yes, Your Honor.
And if for some reason you have an agreement prior to August the 30th at 2 p.m., let us know and we'll put you on the morning docket.
Yes, Your Honor, and I will speak with him in the upcoming week.
Okay. All right, if nothing further, the parties may be excused.
Thank you. Your Honor, I do have one more, but I would ask the court to take this one out of turn. I'm trying to make sure my client logs in.
Okay, I'll recall it shortly.
Thank you, Your Honor.
Okay, Mr. Alamia?
Thank you, Your Honor.
Can you hear me, Judge?
Yes, I can, sir.
Number 20,
Okay, that is F4053189 in the matter of the marriage of Eva Salinas and Oscar Salinas Jr. And do we have Ms. Rocio present? Okay, this is a status. Do you want to give the court the status?
Your Honor, if I may, we were set for mediation with David Cáceres, but I had to postpone since I was in the hospital. And I just barely got out of the hospital. So I apologize for the inconvenience for everybody. But we need to have a setting for a mediation and then hope that we can resolve it. If not, we just set it for a trial
Okay.
day.
Well, no need to apologize. You have no control over your health. I'll give you time to go back to mediation with Mr. Cáceres and let's have a status. Can you all mediate that within the next 30 days?
We can try, except that we have tried to contact Mr. Cáceres already 3 times, but he hasn't responded.
Okay.
I hope he's not here, but unless the court wants to appoint somebody else.
Let me go ahead and have my staff contact Mr. Cáceres' office to see what the reason is that he hasn't responded. I don't know if he's in treatment right now. If he's unable to be the mediator on this case, we will certainly reassign someone else.
Okay, Judge.
Okay, so for right now, I'm just gonna reset your status to July the 26th at 9:30, just so that I don't lose track of the case.
Okay, Your Honor.
Okay?
Thank you.
Okay, thank you. Ms. Portis?
Yes, Your Honor. I am here on 3 cases, but I do have opposing counsel on one of them, and that is number 19 on the docket.
Okay,
Actually,
who is opposing counsel?
Number 13 on the docket.
Well, I see Mr. Guerrero is on, so are you talking about number 13 or 19?
Number 13, I apologize.
So let me call CL 162724-I, Geico versus Andres Gomez et al. Mr. Guerrero, are you also making the announcement on behalf of Mario Ramirez?
No, not on that one, Judge. I'm here on a different one.
So you're not on there because I do have your name on here.
Yes. I've got my wires crossed. Yes, that's my case, yes. There's a motion for summary judgment that was filed, and we've had filed the special exceptions to the motion that was on file.
Okay, and that's your motion for summary judgment?
No, this is Geico versus Andres Gomez and Walter Gomez.
Yes, I know.
The movement, Judge.
But it's because you said that motion we've had filed, so.
We filed the response to the motion, the plaintiff's special exceptions to the defendant's motion for summary judgment.
Okay, so then Ms. Portis, are you ready to proceed on your motion for summary judgment?
I am, Your Honor.
Okay. Go ahead.
Go for it. Okay. Yes, Your Honor. We filed a motion for summary judgment on February 5th of 2021. Defendant, or one of the defendants, has responded to it. The other has not. It's my understanding Mr. Guerrero only represents Mr. Gomez.
Walter
Gomez. Okay. Attached to our motion for summary judgment is 3 exhibits. One is a petition, the petition for the case that was filed back in 2016. Second is a business records affidavit that was completed by Candace Jackson Tate and on August 30th of 2016. And then Exhibit C is a police report. Exhibit C in the police report shows that the officer cited Ms. Gomez for failure to control speed, establishing that she was in fact a negligent and approximate cause to the damages that are outlined in the business records affidavit. We've got property damages of $7,417.02, medical damages in the amount of $9,978.36, and a deductible in the amount of $500. We're showing that Geico has paid that out to the insured Tiffany Miller, and that they're subrogating that claim on both of the defendants. I'd ask the court to grant judgment as requested.
Mr. Guerrero, any response?
Absolutely, Judge. We filed special exceptions as to the attachments on the motion for summary judgment. The motion for summary judgment attached the accident report and attached a statement, a sworn affidavit by a records custodian, not a witness to the actual accident. Now, the theory of relief against Walter Gomez, who's the owner of the vehicle, is negligent entrustment. There's nothing in the summary judgment motion, nothing in the accident report, no scintilla of evidence that shows that ostensibly Walter Gomez was negligent in entrusting the vehicle to his son. You must show that there was some negligence on the part of my client, Walter Gomez. I don't see how anything in the motion takes the court or takes the plaintiff to the point where they're entitled to a motion for summary judgment on the negligent entrustment. But to simply add Mr. Gomez to the petition and say he negligently entrusted is not enough. And that's our argument.
Okay, give me a moment. I'm pulling it up because I wanted to make sure. So, let me see. Okay, so you filed your response on behalf of both Andres Gomez and Walter Gomez?
That's correct, Judge.
Okay, so then
Oh, go ahead, Judge.
your announcement today and your arguments today are also on behalf of Mr. Mario Ramirez, or is he no longer on the case?
He's no longer on the case, Sean.
Okay.
If the court examines the affidavit, you'll find that it's not a witness who witnessed any facts of the case other than a records custodian
Okay.
and an accident report.
And the reason I ask is because the special exceptions to defendant's motion for summary judgment was filed by Mr. Ramirez.
Yes, this one, he had the case, but I took over the file. I mean, it's still inures to the benefit of the two defendants. I understand that he may not be here, but the response was filed on behalf of the defendants. For some reason, it's not allowing me to access the motion exhibits.
It's not because I'm not sure how I do show you as the attorney. The clerk has you as the attorney for Andres Gomez. And I don't see that there was ever either a notice or something. I'm not sure how you came on, because I do see an answer that was filed back in September of 2016, but that answer, which was on behalf of Walter Gomez and Andres Gomez, was on behalf of Mr. Ramirez. And then after that, I don't see that a motion for substitution was filed.
Go ahead.
I saw the motion to withdraw.
And there's a February 24, 2021 notice of appearance.
Okay.
I filed on behalf of Walter Gomez and Andres Gomez.
Okay. Was the order granting ever signed?
The order granting withdrawal? I'm not certain, Judge. Let me see.
I don't see that it was signed. It's because it looks according to the docket sheet like it needs to get cleaned up. So I'm gonna ask that the order to grant the withdrawal be forwarded to my queue, and then I'll go ahead and sign that. Because the notice of appearance would only be proper if the order granting would have been signed. Other than that, it would have been a substitution. But either way, we'll get it cleaned up. Okay, so then your arguments today are for both Mr. Andres Gomez and Walter Gomez. So the court will
Yes.
take it under advisement. And do you all have your orders on file?
Yes, Judge, and I want to point out one thing about the affidavit, if the court will notice, and it finally became available for me to inspect. On the affidavit that was provided by a Candice Jackson Talley, she purports that there's 108 pages of records that are supposed to be attached to this business record affidavit. The court examines the actual attachments to the affidavit. There's only the accident report. There's no substantial evidence on any of the injury, any of the property damage. And so, Judge, I mean, this is the reason why we filed this, for the special exception was filed. I mean, there's not enough to take the plaintiff to the judgment that the plaintiff is requesting. And so that's what the problem is with the motion for summary judgment.
Okay, anything else, Ms. Portis?
Yes, Your Honor. So if the Mr. Gomez, as far as the summary judgment goes to him, I would ask the court to at least consider granting partial summary judgment against Andres Gomez. There is an offense report attached that shows that she was cited for failure to control speed. I'm not sure why the business records affidavit keeps being pulled up as far as negligence. It's standing on its own as far as damages. So we do show damages. We do show that the operator of the vehicle was cited in the negligent entrustment issue. If that's outside the scope of this motion, I ask the court to at least grant a partial summary judgment.
And to that respect, Judge, there's perhaps there's an argument to be made on causation, but the damages aren't substantiated other than an affidavit of a person who did not treat the victims in this case. The affidavit has 108 pages that it purports to have, has no pages attached other than the accident report. There's a computation of damages on property, medical, and none of it is substantiated. If this was before a jury, we'd have to have some testimony as to the injury sustained by the plaintiffs or the victims of the accident. So I don't think there's absolutely not enough to get them past any of the hurdles. They just can't get, not with this motion for summary judgment.
Okay. Just have your orders on file, take it under advisement, and just for the record, this didn't qualify as a quick announcement, okay? So in the future, it's either quick announcement means quick announcement or wait till the end. Okay. So if nothing else on this, I'll set a tickler for myself. Okay, do you have anything else, Mr. Guerrero?
Nothing else for me.
Okay, then you may be excused. And Ms. Portis, what's your next case?
These actually are quick announcements, Your Honor, sorry. At number 18 on the docket, we filed a motion for default judgment on it. We just need an order setting hearing.
That you all need to file an order setting hearing?
Yes, Your Honor.
Okay, and that's on CL 200614 -I, Bank of America
Yes.
versus Aide Valdez?
That's correct.
Okay, we'll get that order setting hearing filed and we'll go ahead and get that set for you. Okay,
And
and
I have
then
number, I'm so
19,
sorry.
that's
Yes,
okay,
Your Honor.
CL 202833-I, Jefferson Capital Systems versus Edna Munoz.
Yes, Your Honor. Clerk Portis here on behalf of the plaintiff. This one also set for status conference today. We asked the court to keep this on the docket. We will file a motion for default judgment and an order setting hearing in the next 60 days.
Okay, I'm gonna set a tickler for this for August the 27th. And just to see if you've already filed that, and if not, then it'll be placed back on the drop docket.
Thank you, Your Honor.
Okay, anything else?
That's all I have. That's all I have.
Thank you.
Thank you.
Okay, Attorney David Solis.
Good morning, Your Honor. David Solis on behalf of Renato Reyes, number 17 on the court's docket, page 3.
Okay, CL 181716-I, Renato Reyes versus Kimberly Zuniga.
Good morning, Honor. Payne de la Garza on behalf of the defendant.
You're back from maternity leave, Ms. De La Garza.
No, I haven't had my baby yet. I'm just, bigger and bigger every day.
Oh, I was like, wow, you and Miss Flores just like the next week, she was like back in court. I'm like, no.
No.
Okay. All right, and what are your announcements, counselors?
Your Honor, we're here for a status hearing, and I think the only thing we need is a trial date. I don't know if you're giving those out yet, but.
Okay. Actually, we're not just yet, but we should be prepared to.
Okay.
Pretty soon. What I've been doing is I'm gonna give you a second status for September the 27th. And then by then, I should be able to give you some dates that we're looking at as far as when we're gonna start setting the jury trials.
Okay.
So we're gonna just have to give you a second status for September the 27th at 9:30 a.m.
Okay.
Sounds good. Thank you, Honor. That's all I have. May I be excused?
You certainly may.
Thank you, Your Honor. May I be excused also?
You certainly may. Thank you.
Okay.
Okay. And I had, oh, there he is. It's CL 174923-I, Angela Gomez et al. Versus Yasmin Cardosa. I have Mr. Kosofsky.
Good morning, Judge. Dale Kosofsky here for plaintiffs.
Good
morning. Good morning, Your Honor. Analisa Figueroa here for Yasmin Cardosa.
Okay, good morning, counselors. And what is your announcement this morning?
I had actually filed a DCC and it was changed to a status hearing this morning. I just heard your announcement about the September 27th. This is an old case. We've attempted to mediate. The policy was exhausted. We've extended that, but unfortunately, well, Mr. Kosofsky can answer to his clients.
Judge, it was a big accident. Lots of people were involved, and most of the policy was paid out for my clients. I guess got offers, and they're not willing to accept what's left. I've explained everything to them, but I think 6 people in a box are going to have to tell them what's going to be what.
Okay, I don't have a problem with that. The only thing is, of course, the dates and the scheduling. So I'll have to do the same. I'll have you come back on September 27th at 9:30, and hopefully we can have better direction to provide you at that time.
Okay.
Thank you, Judge.
Thank you, Your Honor.
Okay, y'all have a great day.
Thank you.
Okay, F 3896-089, in the interest of Jaden Pierce Cornell, I have attorneys Catherine Garcia Perez and attorney Gregorio Lopez.
Good morning, Judge Greg Lopez. I represent Mr. Jeffrey Cornell.
Good morning, Your Honor. Catherine Bettis representing Patricia Rosser.
Okay, good morning. And what is your announcement, counselors?
Judge, what I have is a pending motion to withdraw.
Okay, and did all the proper notices go out?
They were, Judge.
Okay. Ms.
Your Honor, I have no objection to the motion.
Okay. There being no objection, the court will grant your motion to withdraw. Is
I don't see him.
Is the respondent still incarcerated?
He is, Judge.
To our knowledge, Judge, yes.
Okay. Do we have a time frame as to how long his incarceration will be?
I do not, Judge.
Okay. So is he in there because he hasn't been able to post his, go ahead.
Your Honor, it's my understanding that he has 3 violations of a protective order, and so there are 3 pending felony charges. I don't know beyond that what may happen. I assume the reason he hasn't posted bond is because there were multiple violations.
Okay.
Of course, I'd like the court to rule on Mr. Lopez's motion, and then I'll make a request.
Okay, I did. I granted his motion to
Oh,
withdraw.
I'm sorry, I didn't hear that.
It's okay.
Okay.
May I be excused, Your Honor?
You certainly may, Mr. Lopez.
Thank you.
Okay, and you may
So, Your Honor, we're requesting a final hearing be set on this matter.
That's fine. Okay, do you have a good address as to where to send him notice for the final hearing?
I do have the last known address.
But it would have to go to his, to where he's being incarcerated.
I can look that up, Judge, if they'll let me know. As I understand, I believe he was at Rutgers at one point, but has been transferred. I would have to call, but regardless, the Hidalgo County Jail should be able to tell me his location.
Okay, so then how much time do you think you'll need in order to get proper notice to him?
I would say 2 weeks, Your Honor. I can track him down this week and get it mailed out and make sure that mail gets sent out.
Okay, the earliest I have is July the well, actually, you know what? Let me see, Ms. Rivera, you were saying, go ahead.
Judge, and I'm saying 2 weeks off my work brain, but Judge, I'm supposed to be out on vacation in July. I hadn't thought of that as I was talking to you. So
Well,
maybe early August.
Okay, the thing is that if they have him here, we can set him when I have my jail pod in the afternoon.
Okay.
Which would be on a Tuesday or a Thursday. If you want it in early August, that's fine. We can do, we do have a docket on the 5th, August the 5th. And we can have it at August the 5th at 1:30.
Okay. I'll make sure that he gets notice of that date and time. Do I need to include any other additional information since you're going to attempt to have him on by Zoom to the jail?
No, I mean, just if you, did an ad litem ever get appointed on this case?
No.
Okay. And no, just if you have any exhibits that you want to submit prior to that date, just file them before that time. And
Yes, Judge.
Just whatever witnesses you want to have. I'm sure.
And Judge, the child is a teenager. We had previously filed a motion to confer. If the court is more comfortable conferring with the child, since there's been no ad litem, we can have that arranged beforehand if you'd like to.
We can set that up. I'll tell you that it'll probably be the week of July the 19th, that week.
Yes,
we can
Judge.
pick a date and we'll be in contact with your office and we'll set something up.
Perfect, Judge. Thank you so much.
Okay.
All right. Thank you. That's all I have. May I be excused?
You certainly may, ma'am.
Thank you.
Okay. Okay, Mr. Chapa, Jose Chapa.
Yes, Your Honor.
Okay.
Here for the plaintiff on CL 21-1835I.
Okay, and do you know what number that is on the court docket?
Number 10.
Okay. And who do we have on the other side?
Tony Rodriguez, Your Honor, for Clear Blue Insurance Company.
Okay, and what are the announcements, Counselor?
So we have a plaintiff's motion to compel mediation. And this is a first party insurance claim, Your Honor, for damages suffered as a result of Hurricane Hannah. Plaintiff is alleging various causes of action, including but not limited to violations of the Texas Insurance Code and the Texas Business and Commerce Code, both of which provide that mediation is required when a party moves for it within 90 days after service of a pleading. In this case, that would be the original petition, which was served on May 14th, and the 90 days would be August 12th. So it is timely filed.
Okay, Mr. Rodriguez, any response?
Your Honor, I obviously can't agree to mediation, but would advise you that the carrier invoked appraisal. It's gone through the appraisal process and the appraisal award has been paid. So frankly, I'm not sure how much good it'll be to go to mediation, but if you order it, we'll be there.
Okay, well, I'm gonna grant their motion for mediation, and I'm gonna order mediation with Daniel Hernandez. And for that to be done prior to the August 12th deadline.
Your Honor, because of summertime and people trying to go on vacation, I guess, if we need more time, we come back to you and ask.
Well, you can, or extend professional courtesies to one another. I would expect that we all know that it is summertime and it is difficult with scheduling. So sorry, give me one moment. Let me mute Ms. Williamson. Okay.
Yeah, we'll work with each other, Your Honor.
Work with one another on it, but I'll be glad to help you all out on that.
Much appreciated, Your Honor.
Thank you, Your Honor.
Anything else?
That's it. May we be excused?
You certainly may.
Thank you.
Have a good day, Judge.
Likewise. Ms. Cantu del Bosque, what do you have today?
Good morning, Your Honor. I'm on number 2 on the docket.
Okay, F0893-21-9 in the matter of the marriage of Heather Munoz versus Jorge Aranda. And is Mr. Aranda still pro se?
As far as I know, yes, Your Honor.
Okay, and Mr. Aranda, can you unmute yourself, please?
I don't know that he's present, Your Honor.
It's because I see George's iPhone. I thought that was him. No? Okay, so you have Heather Munoz on your client, is that correct?
Yes, Your Honor.
Ms. Munoz, do you speak English?
Yes, ma'am, I do. Good morning.
Okay, good morning. Do you see your husband on the screen?
Yes.
Okay, which one is your husband?
Oh, if he's here, no, he's not here.
Okay, so let me go ahead and have my bailiff call out his name 3 times.
Yes, ma'am. Jorge Alberto Aranda. Jorge Aranda. Jorge Aranda.
Okay, the name being called out 3 times. No response. Mr. Cantu del Bosque, do you want to proceed?
Yes, Your Honor. If I may have my client sworn in.
Sure. Ms. Munoz, please raise your right hand.
Yes, sir.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, ma'am?
Yes, ma'am.
Okay, you may proceed.
Thank you, Your Honor. I would ask that the court take judicial notice of all documents on file with this court's file.
So noted.
Thank you. Ms. Munoz, can you please state your full name for the record? Ms. Munoz, can you hear me?
Yes, ma'am. I'm sorry, I didn't hear what you said.
Okay, Ms. Munoz, are you the same Heather Munoz that filed for divorce in this case against Jorge Alberto Aranda?
Yes.
Is your full name Heather Munoz?
Yes.
And prior to divorce, did you reside in the state of Texas for at least 180 days and in the county of Hidalgo for at least 90 days?
Yes, ma'am.
And of this marriage, you were married on or about February 10th, 2012 and ceased to live together as husband and wife on or about September of 2015. Is that correct?
Yes, ma'am.
And you're asking for a divorce because of discord or conflict that destroys the legitimate ends of the marriage relationship and because there is no expectation of reconciliation. Is that correct?
Yes.
Okay, and did you and Mr. Aranda have any children during the?
No.
And were any children adopted by you or Mr. Aranda during the marriage?
No.
Did you incur any community property during the marriage?
No.
Did you incur any community liabilities or debts during the marriage?
No, ma'am.
Are you asking this court for a divorce?
Yes.
And so are you asking that each of you be awarded whatever personal property is in your respective possession?
Yes.
Your Honor, I have nothing further from this divorce or for this case, Your Honor.
Okay, the court will grant the divorce as testified to and will be set forth in further detail in a divorce decree to be submitted by what date, Ms. Cantú?
I can have it within a week.
Okay, then I'll go ahead and I'll set a tickler for a reminder for me on July the 9th. And just make sure that your client signs off on it.
Yes, Your Honor.
Okay.
Thank
Ms. Munoz, best of luck to you, ma'am. Stay in close contact with your attorney so you can sign off on that decree.
Thank you, ma'am.
Thank you, Your Honor. That's all I have before this honorable court. May I be excused?
You certainly may.
Thank you. Have a good day.
Okay.
Yes, ma'am.
Mr. Molina. Mr. Molina. Silvano Molina.
That's correct.
Okay.
Oh,
You and your wife, Victoria Molina, is also on. Is that correct?
that's correct.
Okay. Ms. Molina, you filed for divorce pro se?
I did.
And Mr. Molina, you're pro se?
Yes, that's correct.
Okay, let me just double check your pleadings. Have you all filed the divorce decree with the court?
Yes.
we have.
Okay. Do you have any children?
We do.
So you filed your petition for divorce on January the 8th. Let me just check that. You all used the old standard? Is there a reason why you chose Wednesdays instead of Thursdays?
That was just, no, there is no specific reason.
That's under the old family code. So whatever you use to copy, it's an old one, but you're going to be stuck with it.
That's fine.
Who's providing health insurance?
I am, Your Honor.
Okay. Your decree states that Victoria Molina is to provide medical support and coverage. So your divorce decree is incorrect.
Well, it was agreed upon that the children would be under his coverage, but we would pay half of the premiums, that we would go 50-50 on the premiums.
That's correct.
Okay, but that's not what it says in your divorce decree. The divorce decree says that Victoria is responsible for coverage. And as a matter of fact, you do not even address the premium, you do address uncovered expenses, but
Is
you
it,
do not address the premium in here. Go ahead.
is it not stated further down or maybe just somewhere else in there? Because I thought it was.
In the section of, do you have the decree in front of you?
I don't. I have it in an email. Silverado, maybe you have it in front of you.
I do have it in front of me. And I'm checking under healthcare. And it's stating that you're responsible for the medical support and coverage. And if there is no health insurance available through either of your employment, then that Miss Molina is the one that is supposed to get coverage. And it does state that any healthcare expenses not paid by the insurance and incurred by the children would be divided 50-50, which is what the family code states. But it does not state anything about any premiums. It doesn't state who will be the one responsible for paying the premium or if you guys are dividing it up in half. So what I'm going to do, I'm going to go ahead and let you all put on your testimony, but you need to get your decree fixed. And I'm going to set a date for a status, at which time if you do not submit your decree by that date when you come back, then I'm going to drop your case. So even though you're going to do your testimony today, I'll pronounce you divorced. You're not divorced until I sign that divorce decree.
What if we're okay with how the decree states at this time?
Where you're fully responsible?
Yes.
That's not up to me. If that's what you all want.
That's fine to proceed the way that it states.
Okay. You're fine with that, Mr. Molina?
Yeah, I'm okay with that, Judge.
Okay, both of you raise your right hands. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Molina?
Yes.
Mr. Molina?
Yes.
Okay, you may lower your hands. Ms. Molina, please state your full name for the record.
Victoria Lynn Molina.
And what is your husband's name?
Silvano Molina III.
Okay. And at the time that you filed for divorce, had you been a resident of Hidalgo County for at least 90 days and a domiciliary of Texas for at least 6 months?
Yes.
And are you asking the court for a divorce today because your marriage has become insupportable because of discord or conflict that destroys the legitimate ends of your marriage?
Yes.
Is there any chance for reconciliation?
No.
And on what date did you and your husband marry?
July 26, 2006. July 21st. Sorry, July 21st, 2006.
Okay, and what date did you separate?
July 27th, 2020.
Okay, and how many children do you have?
2.
And go from the oldest to the youngest with the name and the age.
Ethan Lee Molina, 15. Mallory Lee Molina, 13.
And are you currently expecting a child from the marriage?
No.
Are you currently expecting a child at all?
No,
Are there any other children that have been born or adopted into this marriage?
no,
Okay. Have you and your husband come to an agreement with respect to your property division and conservatorship?
yes, I'm sorry, I didn't mean to interrupt.
Okay, and how about as to visitation, possession, access, and child support?
Everything has been agreed upon.
Okay. So according to your divorce decree, you are to serve as primary managing conservator. You are to serve as primary of the children to decide where the exclusive residence of the children will be. Is that correct?
Yes,
And both of you will be joint managing conservators of your children. Is that correct?
that's correct.
And you are asking the court to approve a geographical restriction to Hidalgo County. Is that correct?
Yes,
Okay. And according to your divorce decree, your husband has agreed to pay child support in the amount of $300. Is that correct?
I believe that's me.
Well, who is going to be staying with the children?
I am, Your Honor.
I'm sorry?
I am.
I don't know that I read that on your decree. Hold on.
Yeah, it's on there. Let me see if I can find it.
I'm looking under conservatorship. It says that you all are joint managing conservatorship. Conservators, I'm sorry. And both of you are being assigned the same rights and duties.
All right. Application. Application. Because I found a little section here, there's no credit for formal payments. It is ordered that the children's support as prescribed in the decree shall be exclusively discharged in the manner ordered. Any direct payments made by Victoria Molina to Silvana Molina or any
Hold on,
extra.
Mr. Molina, you're reading too fast. My court reporter has to take what you're saying. I understand what you're saying as far as the child support and where it says that. However, you all do not have that in the conservatorship section. You do not assign, you are not named as the primary managing conservator. You're not neither one of you is actually named as the person to have the exclusive right to determine where the child's permanent residence should be. Neither one of you.
Okay, I got you.
So just because it says that she's going to pay you child support doesn't make you automatically primary. So
Pretty sure it said something in there. Maybe we can have a few more minutes for him to review the decree because I'm pretty. I read it. I took the time and I read it. You know.
well, I sure hope so because you're giving up custody of your children. So I'm hoping you did read it. So I'm not saying that you didn't read it. What I'm telling you is that I don't see it on there. So I'm going to recall your case shortly. I do have other attorneys that are waiting. So because you all have chosen to do this pro se, I'm treating you as attorneys. And so I'm holding you to the divorce decree that you filed and both of you signed off on it. And so you all need to read that divorce decree and let me know where it says that one of you is given the right to decide the exclusive residence of where your children will reside. Other than that, neither one of you is being named primary the way that I read it. So I'll recall you shortly. I can go ahead, if you need to converse with one another, just go ahead and log off, and then you all can discuss it via telephone. and I'll call you and I'll recall you. So if you end up needing to log off, I'll let you back in. But I need for you to tell me the page number where it's at, because I'm not seeing it. I do see where now, when she pointed it out, I do see where it says that Miss Molina will pay you child support, but I do not see where it says that you will have Mr. Molina the exclusive right to determine where your children reside.
Okay. I got you. And there's no way to add that to the testament or amend that?
No, you can add it to your testimony, but you will have to revise the divorce decree.
Gotcha. Okay.
Okay, and I also will be asking as to why Miss Molina is only going to be getting standard instead of either extended standard or some form of alternating weeks or something like that. I'm gonna ask for more testimony. Just because you all signed off on the decree doesn't mean I have to accept it. So I do have some questions of my own. So, I mean, either you all can agree to write that in and you all initial it where it says, but it's specific language that has to go into that divorce decree stating that one of you will have the exclusive right to determine where the residency of those children will be.
Gotcha.
So speak to one another about it, whether you're just going to insert it and, you know, you all see each other so that you both can initial that line and then you can refile it, or let me know what you're going to do, but I'll recall you shortly, okay?
All right. Thank you.
Okay. Ms. Williamson, did you find your client?
Yes, Your Honor, he is on the screen. It's under Jorge's iPhone, and we have a default.
Okay, so Mr. Jorge Nino is your client?
That is correct, Your Honor, and we are the move-ins in this case. It's a motion to modify.
Okay. And Ms. Nino was properly served?
Yes, she was, Your Honor. I would ask the court to take judicial notice of all documents on file, including the citation served 9/29/2017, her subsequent answer October 18, 2017.
Okay, give me one moment.
Yes, Your Honor.
Okay. The court will call F-30-68-12-9. And this is in the interest of KN, CN, and VN, all minor children. The court will further take judicial notice of all the documents on the court's file. And Mr. Nino, to your knowledge, Ms. Nino is still residing at 513 North 7th Street, McAllen, Texas, 78501, sir?
She is.
Okay. And Mr. Nino, go ahead and raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, sir?
Yes, ma'am.
Okay, Ms. Williamson, you may proceed.
Thank you, Your Honor. Mr. Nino, can I have your full name?
Jorge Nino.
All right, and you are the father of the 3 children, the subject of the suit, correct?
Yes, ma'am.
Now, you were divorced from your wife back in 2017, correct?
Yes.
And I'm sorry, 2016. And pursuant to that divorce, your wife was granted primary, is that correct?
Yes, she was.
Shortly after the divorce, all the children came to live with you, is that correct?
About a year afterwards.
Okay, and in September of 2017, you filed a motion to modify because the kids were with you, correct?
Yes, ma'am.
Okay, and is it true and correct that a temporary order was entered back in October of 2017 where you were granted custody of the children?
Yes.
And pursuant to that order, the issue of child support was left pending until today's hearing, correct?
Yes, ma'am, it was.
All right. At this time, are the children still residing with you?
Yes, they still are.
And does their mother visit them on a regular basis?
No.
Okay.
doesn't.
I believe one of your children had a birthday this past week.
Yes, it's this weekend.
Okay. Did their mother make any contact for the birthday?
No, she didn't.
Okay. At this time, are you asking that you and their mother continue as joint managing conservators, but that you be the primary?
Yes.
Okay. And is it true and correct that you are asking for child support, correct?
Yes, ma'am.
All right. Now, we have filed some exhibits, and based on her pay stub, her child support, we were provided some pay stubs, correct?
Yes.
And based on her pay stubs, with a gross monthly income of $3,285.44, she would be required to pay child support for 3 children of $835. Is that correct?
Yes, ma'am.
And you are asking that she be required to pay that,
Yes.
and with the appropriate step downs as your children emancipate, correct?
Can you repeat that again?
That the child support decrease as your children turn of age.
Yes, yes, yes.
Okay, and those amounts being $695 and then $556 when you only have one left.
Correct.
Under the age of 18. Okay.
Yes,
Who is providing medical insurance for these children at this time?
right now she is.
Okay, and you are asking the court for it to continue that way, correct?
Yes.
You understand that any unreimbursed medical expenses will be split equally between you and the children's mother. You don't have any objection to that, do you?
No, I don't.
No. Mr. Nino, we also pled for or requested child support back when this was originally requested for modification back in 2017. Now, you're not asking at this time for child support since 2017, correct?
Correct.
Okay. You're just asking for the last 2 years, correct?
Yes, ma'am.
And based on what her earnings were, we are asking for retroactive child support for the number of months since the children, since 2019, 2020, and what is of 2021. Is that correct?
Yes, ma'am.
Okay. And that would be retroactive child support of $25,050. Is that correct?
Yes.
And you are asking that she pay that back to you at a rate of $200 a month in addition to her regular child support, correct?
Yes.
To your knowledge, what does she do for a living?
She's a funeral director.
Okay. And how long has she been doing that?
About 7 or 8 years, maybe.
Okay. And I know you testified that she doesn't visit often, but you have no objection with her visiting, do you?
No, I don't. I mean, that's on her. It's not on me.
Okay. And you don't have any problems with her having the standard visitation if she so wishes to exercise it?
Correct.
Okay. I have nothing further, Your Honor.
Okay, just for my notes, how much did you say that she was her income? Was that net or gross?
That is gross $3,285.44 per month.
And she provided that income information to you?
Yes, Your Honor, and it's been filed with the court.
Okay. And from 2017 to 2019, he's not asking for any retro support?
That is correct, Your Honor. He is not, just starting 2019.
And the amount of child support per month was what?
$835 per month, Your Honor, for a total of, we're asking for 30 months with a step down to $695 and $555.
Okay. So, Mr. Nino, your three daughters are 17, 16, and 12 right now?
No, 17, 15, and 14.
And how are they doing in school?
I'm sorry?
How are they doing in school?
They're doing good.
Okay. The court will take judicial notice of all the documents that are in the court's file, specifically the that Ms. Nino was properly served, and she did file an answer, however, has failed to appear today, although being properly served of today's hearing. So the court will grant the relief as requested and testified to by Mr. Nino, and it will be set forth in the final order to be submitted to the court by what date, Ms. Williamson?
Your Honor, if you could give us till Friday?
That's fine. I'll go ahead and set a tickler for July the 9th in case you get backed up with anything.
Thank you, Your Honor.
And that'll have to be signed by your client as well.
Yes, Your Honor.
Okay.
Thank you very much, Your Honor. I have nothing further, and I apologize for the delay.
That's fine.
Thank you.
Okay, thank you.
Thank you.
Best of luck to you, Mr. Nino.
Thank you, ma'am.
Okay, let me call F 5266-19-9 in the matter of the marriage of Erica Espinosa versus Juan Ramos. I see Ms. Espinosa on.
Your Honor, good morning. Jesse Contreras for Mrs. Espinosa.
Good morning, Judge. Daniel Sorrells for Juan Ramos, Judge.
Okay, Mr. Ramos, please remove your cap. Okay, and are we ready to proceed?
It's my motion, Your Honor, that I filed for some guidance on this issue, the issue of written notice by April 1st. I know that my client was saying that he's never received. So I told Danny, Mr. Rellis, that I was going to sign a motion, file a motion to see what the court can clear up this issue. And that's why we find ourselves before this court on that issue alone, on whether or not there was written notice given to Ms. Espinosa. I would like to proceed by putting on the first witness if possible, Your Honor.
Well, let me hear Mr. Soros. What do you
Okay.
have to say, Mr. Soros?
Judge, from our position, we did file written note, or we did send out written notice, whether she received it or not. You know, we sent it to the address that we have. I believe this is what they've done for many summers, Judge. This is a divorce. However, there's a SAPSER from, I believe, around 2015. This is kind of how they've treated the summers. We also have our own motion to enforce that we're trying to get Ms. Espinosa served on, and then hear that at a later time, Judge. But there's been a pattern of her not allowing Mr. Ramos to see the kids or to talk to them on the phone. And it's frustrating on my end, having Mr. Ramos, call and text me, late at night, just saying, complaining that he hasn't been able to see his kids. And, I feel really bad for Mr. Ramos that, he hasn't been able to exercise his visitation, hasn't been able to foster his relationship with his kids. So we're asking that, the kids be tendered over to Mr. Ramos for the summer vacation. That way he can, kind of gain the time that he's missed with his kids back.
Okay, well, we're going to take it step by step. Hold on. Okay, for my purposes. So where does Ms. Espinosa live? In what city?
You can answer that, Ms. Espinosa.
You're on mute. You're still on mute, Miss.
Okay, there.
Yes. What city do you live in?
San Juan, Texas.
Okay. And Mr. Ramos, where do you live?
I live in Falcon and here in McAllen, Your Honor.
Okay, but you live in McAllen, is that correct?
But yes and no, because I reside in both places.
Okay. So I'm gonna ask the attorneys, tell me, okay, so is he giving, are you all asking Mr. Contreras for notice by April 1st because he's choosing other dates outside of July 1st through July 31st?
Well, what happens, Your Honor, what we have now is that sometimes he
No.
decides.
Just Mr. Contreras, just answer the question, because if not, we're never going to get out of here. A docket
Yes.
that should have taken an hour or so has now
Yes.
extended past going on 2 hours. So
Yes, Your Honor. Yes,
is it because he's requesting other dates other than July 1st to July 31st?
that's correct, Your Honor. Yes.
Okay. What dates is Mr. Ramos requesting?
Mr. Ramos, what dates are you requesting?
We've been doing the.
Now, Mr. Ramos, listen to what I'm asking, okay? I'm gonna ask questions from both of you. And I want you just to answer my question, okay? Not any more, not any less, just answer the question, because we will have a resolution today. Because I'm gonna tell both of you, I do not look kindly on parents withholding children from the other parent, nor do I look kindly if someone is not telling me the truth. Okay, now if we're gonna get stuck on whether or not he had given notice or not given notice, then we're gonna resolve it today. Because I'm gonna tell you that as co-parents, and as long as the history that I've been seeing on your docket sheet, you all should encourage one another to see your children, unless you have some evidence for me that states that either one of you harm your child in a way that is illegal, then your children will see each parent, okay? Because I'm not gonna play games at all. So we wanna get stuck on whether or not he gave notice on April the 1st, then we're gonna resolve it today. So Mr. Ramos, what dates were you asking to see your children, sir?
June the 4th through July 31st.
Okay. Now, sir, let me go ahead and have both of you raise your right hands. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mrs. Espinosa?
Yes.
Mr. Ramos?
Yes.
Okay, so Mr. Ramos, being that you stated sometimes in McAllen, what makes you think that you are entitled to more than 30 days?
I don't see them as much through the year.
Okay, so Mr. Contreras, in the current order that is signed by the court as enforceable, how many days is Mr. Ramos entitled to?
For the month of July, as we speak today, he's got the whole month of July, Your Honor.
Okay, so in other words, Mr. Ramos is entitled to 30 days as per the order.
Yes, Your Honor.
Okay.
Except for one weekend, that the primary conservator has that weekend to designate in July.
I understand that. Yes, and I'm sure Mr. Sorrells cannot argue with the family code as to that one weekend. Okay, so Mr. Sorrells, what is your understanding as to how many days Mr. Ramos gets as per the court order? Not what your client wants. What does the court order state? And as an officer of the court, is Mr. Ramos entitled to at least the 30 days?
Absolutely, Judge. It is 30 days because they do live within 100 miles of that. But I believe Mr. Ramos misspoke, and I think he's asking for more than the 30 days. However, it was when the children get out of school, which was June, I believe 15th. So not through June 4th through the 31st, Judge.
Okay, so Mr. Ramos, I need you to listen carefully, sir. And I understand both of you are frustrated. And I know that you can't see Mrs. Espinosa's side, and Mrs. Espinosa will not see your side, because obviously you didn't end up here because you guys are still best friends, okay? And I'm gonna speak very candidly. So many times when you are not the primary conservator, I'm sure that you feel that you do not see your children enough. And I know that both of you love your children very, very much, okay? But you are under a court order. So although I'm sure you would want the entire summer with your children, because like you stated in your opinion, you do not see the children enough, the court order states 30 days, okay? Not 42, not 65, not 90. It states 30 days. With 1 weekend within those 30 days that Ms. Espinosa can choose to see the children. It's the designation of the primary conservator. That's the law, sir, and that is what's under the current order that you're operating under. Now, I know you all have had some issues. So I'm going to ask you, I understand you wanted June 4th or July 31st or whatever it is that you were wanting, whether it was June 15th. Okay. First, I'm going to start off with, were you able to see your children for Father's Day this weekend?
Yes, ma'am.
Okay. So you did have your children this weekend. Okay. Did the children go back to mom's?
Yes, ma'am.
Okay. All right. Then at least we're already starting off on the right foot with that. Okay. So Mrs. Espinosa, do you understand? Well, I lost her. Mr. Contreras, your client logged off.
I think it's one of her services. Let me get a hold of her real quick, Your Honor.
Or was kicked, or was dropped. Let me see. Okay, she's back. Okay, Ms. Espinosa, so do you understand that the court order states that your ex-husband is entitled to 30 days during the summer? Okay, I don't know. You're on mute, ma'am.
There?
There you go. Okay, so do you understand that your ex-husband is entitled to 30 days in the summer?
Absolutely.
Okay, so we've got that cleared up. So the April 1st deadline, and this goes for both of y'all, and I'm sure look, you guys may have operated however you've wanted to in the past or however, but it's not until you have a problem that you have to go back and rely only on the court order, okay? So forget about what you've done in the past. Forget about what courtesies you've extended, because you're obviously here because you're no longer going to extend that courtesy or however, whatever it is. And I know that you guys want to say like, well, she used to let me do this, or he used to let me do that, or we used to agree on this. It doesn't matter. It doesn't matter what courtesies were extended prior to. I'm not required to look at habits. I'm not required to look at how did you all handle it. I'm only required to look at the four corners of an order. That's all I'm required to do. So regardless of what has happened in the past, we're going to talk about today forward. Okay. We have now all agreed that Mr. Ramos is entitled to 30 days in the summer. Okay, so we're going to talk about those 30 days. Now, if written notice was given by that April 1st deadline, then he gets to customize his summer possession, okay, which can be done within a 7-day, at least with a 7-day consecutive period, okay? So he could have split up his 30 days in 2 weeks, another 2 weeks, and for the best way that I can describe it is by saying that it's a customized visitation for summer, okay? When notice is not given, then he automatically will get July 1st to July 31st, all right? Now, the April 1st deadline is only critical when you are really wanting some customized dates. Usually it's for trips because you've paid for a certain trip, or usually it's because it's a special occasion. There's many reasons why you would want it customized. Now, Mr. Ramos, understanding that you have 30 days, do you want to exercise other dates other than July 1st through July 31st?
Yes, ma'am.
Okay. Now, what 30 days is it that you're asking for to have your children?
It was the beginning, right after they got out of school.
Okay, that's the past. What 30 days are you asking for now? Because we're way past when they got out of school, because now we're on June 21st. Okay.
So for this year, you're asking, right?
Yes, for currently, like what 30 days are you, if July 1st and July 30 through July 31st don't work for you, and keep in mind, July 1st is only approximately 10 days away. So if in 10 days to get your children does not work for you, what other dates were you asking for?
No, we're good, Your Honor, with what we have. The July 1st to the 31st. I mean, it was just the past that had the issue, but can't go back. So.
Okay. And unfortunately, you're right. And it's very unfortunate that you can't go back. But I need for you to understand in the future, because this isn't going to end right here, is that when next summer comes along, if you're still living in the same way that you're living now in between cities or what have you, within 100 miles apart, then you're still going to be entitled to your 30 days. So if you're going to want to customize that, then give her that notice by April 1st. And that notice can be done via email, via certified mail, via regular mail. Even though you can don't do text message. And really the best way to do it is to do certified letter. And Ms. Espinosa, please accept the certified letter, because I have many people that come before me that they purposely won't accept the certified letter. And if you come before me and he has proof that he sent it and you didn't get it and it's to the right address, I'm going to assume that you didn't want to receive it. And that's a game, and I don't play the games. So look, for this summer, you'll have the July 1st or July 31st as stated. Ms. Espinosa, give them the weekend it is that you're going to want to exercise your one weekend with the children during that time. Do you have your weekend picked yet?
I do not.
Okay. Then I'm going to ask you to please give that weekend to your attorney as soon as possible, because Mr. Sorrells needs to communicate that to Mr. Ramos.
Judge, if I could, I would just ask that my client be allowed to start exercising his 30 days of the summer, maybe tomorrow. I know that the court hasn't heard, but we do have our motion to enforce. I anticipate getting her served on that. And one of the requests that we would make is, rather than put her in jail, is give Mr. Ramos a more extended period of summer. That way he can make it up. And I would anticipate getting her served within the next 30 days. And then hopefully having our hearing within the next 30 days. That way we can give him a little extra time just to make up for the time that he's lost, Judge, because there is a considerable amount of time.
Okay, and when you say he's lost time for his regular visits, because I'm not going to entertain. Okay.
Right, for his regular weekend visits, Judge.
Okay, now you all really need to have a conversation about that, because you're going to have to show me, and you and I, the law doesn't state that there's any makeup of time. Those are courtesies that I do hope to see between parents to give them more time. And, I used to do it too when I was in your shoes, where I would ask for time to be made up during the summer, because but it had to have been proven that she was keeping the children. And yes, absolutely. You're going to have your date to do that in court. Now I am going to encourage you to go to mediation prior that you come before here, because, I don't like it when parents are being taken away their days. So how old are these children?
9.
They're a set of twins?
Triplets, the triplets.
Triplets.
9
years old. Okay. All right. Well, I mean, both of y'all love your kids. You wouldn't even be here if you were both, 3 kiddos, triplets. I mean, that's a lot of work. And both of you want as much time as you can with them. Absolutely. Okay. But I don't know. Do y'all, I'm not going to start it tomorrow because even 9-year-olds need some time to get told, get your stuff together and do all this stuff. Look, he's going to have his 30 days. And you want to make up more time. He still has time in August to do that. So, because
I'll get with Your Honor, if I may. Sorry about that, ma'am.
hold on. So, Ms. Espinosa, do you have an issue with your ex-husband starting his time earlier other than July 1st?
Yes, I do. We have plans.
Okay. So your plans are prior to July 1st?
Yes.
Okay. Honestly, I think that the best thing to do at this point, for the sake of just keeping it as to the order for right now, and I'm not saying that he's not going to make up time. I'm not saying that I'm not going to entertain your order. I'm just saying that we all need to be on the same page that he starts his summer visit on July 1st.
Always.
Okay. So he's going to pick them up on July the 1st. Now, what I would suggest, since you are asking for jail time in your motion for enforcement, she does need to be served personally.
Yes, Judge.
Okay. Now, Mr. Contreras, I don't know if you want to make arrangements with Mr. Sorrells so that she can be served, because I'm not going to be playing this trying to find her game. Okay. Mrs. Espinosa, you had your hand raised?
Yeah, I wasn't aware of that jail thing that he wants me to serve for something.
Yes, it's the enforcement, Ms. Espinosa. I told you they're gonna serve you with a motion for
Yes.
enforcement.
Yeah, they
That's-
serve me, but you
that's-
never said anything about no jail time.
Okay.
Sometimes they ask for jail time, sometimes they ask for sanctions and fines, Mrs. Espinosa. As I told you in the office.
When motion for enforcements are filed and he's claiming on his enforcement that he was denied visitation and access, the family code does allow for the court to consider whether or not to incarcerate the parent that is allegedly keeping the children from the other parent. Okay? It's not to say that you will be incarcerated. It's not to say that I will rule that you will be incarcerated. However, because he has filed it, he is entitled to a hearing on that motion. Now, the sooner that you arrange that service upon you, the faster that I can have you all come before me and we can get that resolved. However, as soon as she is served with that and we receive you receive the citation, I'm going to ask you to assist the court, Mr. Sorrells, and contact my office, because I will be sending an order for referral of mediation so that you attempt to mediate that before your hearing date. I'll give you a hearing date, but you will attempt to mediate it before then. Now, Mr. Ramos, I do want you to keep in mind, you will have your kids during the time period probably where you're going to have to mediate it. I would suggest that you all also try to informally have discussions as to whether or not Mr. Ramos will receive some extra days before the children return to school. Look, as I stated, I'm going to speak very candidly. First of all, neither one of you is allowed to speak to your children with respect to these legal proceedings. Do not. Neither one of you is to speak to your children in a bad form, in a bad manner about the other parent. At the end of the day, you all are both the parents to these three, I'm sure, amazing and beautiful children. So regardless of how you all feel of each other, you are the mom and you are the dad. And that what has been chosen for you all. Okay? You both have the responsibility to be the best parents that you can be. Not partners to one another, because that ship has sailed. Okay? But parents to these kids. Now, We as human beings sometimes tend to want to hurt the other party. And without realizing it, we use the children as the means to hurt the other party. Whenever you feel the temptation to do that, don't. Don't. Because you will be messing up your kids for life. Do not think that I will be impressed of you all bringing evidence to me to show me that one parent has screwed up the kids more than the other parent, unless it is true emotional and mental abuse or physical abuse. Okay? I don't play that. I practiced family law for almost 20 years. This is my arena and this is my specialty. I've seen every argument that you can throw at me. I've seen it. One thing I never played as an attorney are games. I'm a straight shooter, and I expect for attorneys to come here and being straight shooters as well. I never allowed my clients to play the games, so I'm not going to look favorably upon anybody that does as well. Now, if there was denied visitation, not saying there was, the only person that can answer the question honestly would be Ms. Espinosa. Now, if there was visitation that was denied, you all need to look at why, and you all need to look at it reasonably as to whether Mr. Ramos can quote unquote make up that time. In reality, neither one of you will ever make up any time that you feel that you've lost with your children. You just won't. It's not possible. You won't ever make up the time. What you can do is make the best of the time that you have now with your kids. What you can do is make the best of the 30 days that you have consistently, Mr. Ramos, with your kids, and really spend time with the kids. If this year has taught us anything, is that what is truly important to you in your life should be your family, should be your kids. And whether you all like it or not, each of you are a part of one another's lives forever and ever. Your children's milestones do not stop when they graduate from high school. They will continue with weddings. They will continue when your grandchildren come. They will continue with college graduation. They will continue with one accomplishment after another accomplishment after another accomplishment. So the relationship that you all have is never going to go away. I'm not telling you to become best friends. I'm telling you to respect one another and to respect each other's time with the children, okay? Do not be calling and harassing the other party while they have access to the children. Do not be calling and asking the kids, what are you doing? How is it going? Where are you at? Just don't do that, because you are taking away from any time that the party has with the kids. Now, Mr. Ramos, I understand that you are frustrated. Respect your attorney's time. Do not be contacting him at all hours just because it is when it pops into your head. I would have the same problem. It's called boundaries. Boundaries are very important. Ms. Espinosa, I understand you got a little shaken up when you heard about incarceration and jail time. It doesn't mean that I'm going to incarcerate you. However, I am going to entertain the arguments as to whether or not there was a denial of access, possession, and visitation to the children. I'm going to encourage the parties to continue to talk and see what can be worked out. Now, be very realistic. Your children are out on summer break. This is the perfect time to have very flexible visitation, very flexible. So be considerate of one another. It's not going to hurt for him to have a few extra days with the children while they're on summer break. Give a little grace to one another. During the school year, the same thing, Mr. Ramos. You know, be there for one another, be there for the kids as much as you can, okay? If you're still needing your hearing, I will be glad to give it. But for today's purpose of today's hearing, he will begin his visitation on July 1st through July 31st. Ms. Espinosa, please pick your weekend as soon as possible so that you can let your attorney know and he can notify Mr. Sorrells so that Mr. Ramos can plan his 30 days accordingly so that if he has any activities for the children, he knows not to be out, not to plan anything for the weekend that you are choosing. Okay?
Yes.
Okay, have I made myself clear?
Yes.
Okay. Anything else for today?
No, just Danny, you want to call me? Maybe we can work out that enforcement action. If there's anything in there, can you send me the notice that this gentleman sent? And then I can go over it with my client, Danny, if you don't mind. Thank you. Judge, thank you for your time and thank you for clearing up everything. Really appreciate your time, Judge. And hopefully we won't be back, but if we have to, we'll be back with the enforcement action.
Okay.
I'm going to try to see if we can work it out, Your Honor.
Okay.
But I'll wait for Danny's notice.
Okay. Best of luck to both of y'all. Enjoy your summertime with your children. I've always been of the mindset that summertime is a time to reset and reflect and try to enjoy those long days. It doesn't get dark until very, very late in the day. So, you know, find creative ways to beat that summer heat. Okay.
This is the longest day of the year today. We'll see.
So,
Judge, that's all I have. May I be excused, Your Honor?
you certainly may. Mr.
Thank
Sol?
you.
Thank you, Judge. My big excuse.
Okay. Ms. Espinosa and Mr. Ramos, best wishes and best of luck to you.
Thank you, Your Honor.
Thank you.
Have a great day.
Likewise.
You too.
Okay. Mr. and Ms. Molina, have you all worked it out?
We found the section, you know what, that it's missing on that document you have. On my Word, it actually has it. I don't know if I can share my screen, you can kind of see it.
Okay, you are breaking up very badly.
Okay, how about now?
Let's try that again.
Okay, on your file, missing a little chunk of it. Didn't print out for some odd reason. I have no idea why. But on my my Word file here, it has that what you're looking for.
Okay, and the one that you have that is showing the missing information, is that signed by both of you?
That's just the actual the Word file, the one that I used to print it out of. For some reason, when I printed it, it didn't print out that little chunk. If I can, I was gonna try to show it to you, but it is missing like 4 or 5 lines. I don't know if you want me to read that to you, like what.
No, I'm gonna go ahead and share my screen with you. I'm gonna allow you, and I want you to show me the new divorce decree that you will be signing and where it states that. Okay.
Go for it. Where is
Okay, you should be able to share.
It's not new, it's the same one.
Well,
Yeah,
for me, it's new because it's not reflective of the one that's on the court's file.
Okay, I understand.
Okay, can you see this, Judge, my screen?
No, sir.
No. Okay. Sure. Okay, how about now?
I certainly can.
Okay, so on that geographical area for permanent residence, I believe this is a section you're looking for right here. That didn't print out for some odd reason. It didn't print this out. Not even the page numbers came out actually.
Correct. Yes, that is what I'm looking for. And also it needs to be, it's not in the right section. That, it's okay there, but you're also supposed to have that sentence that states that you have the exclusive right to establish the children's primary residence within Hidalgo County, Texas. That is also supposed to be under your name, under the rights.
Okay.
So you will need to also add it, go up. Go up. Okay, slow down. Okay, keep going up. Okay, right there, stop. You see where it says that at all times Silvano Molina as a parent joint managing conservator shall have the following rights?
Yes.
Under that section, you should have it also named there, because that is where a judge or the Attorney General's office is going to be looking for it.
Oh, okay, I got you. So it needs to be here and it needs to be in that below section as well.
Correct.
Okay. Yeah, I mean, we'll have to modify it and have up again. So that
Okay,
we can.
so I'm going to go ahead and if you'll stop your screen share, we're going to go ahead and continue to prove up your divorce. Let me remind both of you that you are still under oath. And what we're going to do is, I was asking at the time from Miss Molina, so let's clarify, Miss Molina, Mr. Molina will be the parent that has the exclusive right to designate the children's primary residence within Hidalgo County. Is that correct?
Correct.
And you will be paying child support to Mr. Molina in what amount?
$300 a month.
Okay. And you will be responsible for the health insurance coverage for your children as per the divorce decree. Is that correct?
Correct.
So you are responsible for the health insurance premium for those children. Is that correct?
Yes.
And do you understand that any uncovered medical expenses, that includes copays, will be divided equally between you and Mr. Molina 50-50?
Correct.
Okay. Now, you all have also entered into an agreement with respect to a division of property. Is that correct?
Yes.
And if you'll bear with me, I took that off the screen, my screen. So let me go back and pull up. And before I forget, when you file your new divorce decree, it has to say first amended agreed final decree of divorce.
Okay, give me
Okay.
that down first.
If not, it'll be rejected.
First amended.
Agreed final decree of divorce. Okay, so Miss Molina, you will be having standard possession of the children, is that correct?
Yes.
You do understand that you can have any other visitation as long as there's mutual agreement by both of you?
Yes.
Okay, and Mr. Molina, it is your responsibility. If you want this withheld from her paycheck, you are supposed to file an withholding income for child support.
Correct.
Ms. Molina, and also to remind you, any direct payments to him, you will not receive credit for.
Okay.
Okay, so Ms. Molina, you and your husband have agreed that you will keep any furniture that's in your possession, any clothing, jewelry, personal effects, any sums of cash that are subject to your sole control, any 401k or any retirement plan that is under, for your employment, and any life insurance policies that are under your name, and any bank accounts, savings accounts, or any financial accounts that are under your name, you will stay with. Is that correct?
Yes.
And he will stay with the same of anything that is under his name. Is that correct?
Correct.
He will further stay with the property that is located at 126 Apollo Drive in Donna. Is that correct?
Yes.
He's further to refinance the mortgage within a year that the divorce decree is signed. Is that correct?
Yes.
Now, you do understand that you will not be relieved of that mortgage being under your name until it's refinanced.
I understand.
Okay. And you've agreed that Mr. Molina is solely responsible for any taxes, any fees that are related to refinancing the loan?
That's correct.
And it's further agreed that Mr. Molina will continue to make all the payments, all the payments on the home, the taxes, and the insurance payments that are related to the home. Is that correct?
Yes.
Okay. And only if he refinances the property, then it'll be awarded to him. Is that correct?
Yes.
Now, I don't see anything on here, but what happens if he can't refinance the property? Have y'all discussed that?
No, we haven't.
Well, y'all need to. I can't approve the divorce decree until you tell me what you want to do.
I mean, as I understood it, he has to, it's part of the decree.
No,
Yeah.
he would have to attempt to refinance. He cannot control whether he is approved or not approved. So if he's not approved, normally what I would do is order the home to be sold and the proceeds to be divided in a percentage to each party.
Okay.
That is what is normally done. Have you all discussed that? Because I don't know, Mr. Molina, are you confident that you'll be able to refinance this?
Yeah. My credit is really good, so it's
Okay.
kept up. So we shouldn't have an issue.
Okay. In the event that it's not refinanced, what are you all going to do?
In the event it doesn't, I think it's just best practice and divided 50-50.
I didn't catch that at all, sir. You broke up.
I'm sorry. I don't know why I'm breaking up here. Is it a bit better?
Yes, sir.
Okay. I think we'd go with best practice and just split it 50-50, sell it and split it.
Okay, so for the record, in the event that Mr. Molina is unable to refinance this mortgage loan within the year of the time that the divorce decree is signed, then it is agreed by the parties that the home will be sold and the net sale proceeds will be divided 50% to each party. Is that correct, Ms. Molina?
Yes.
Okay. Mr. Molina, you'll also have to make that addition in your new divorce decree, okay?
Okay.
Okay. So any prior income tax, do you all know how you're doing your 2021? Did you all already file your 2020 income tax return?
We've already filed and agreed on that. So that's already been said and done.
Okay, so for 2021, you will be filing separate. Is that correct?
Correct.
Yeah.
And Mr. Molina will be claiming the children? Is that correct?
I believe.
He has
I
primary.
So where you want to take that one?
Okay, because right now what we're claiming is basically one child. We have 2 kids, so she can claim one and I can claim one. And I think that's even on there as well.
I didn't see that. You need to make sure to have it on there as to which child you will be claiming and which child she will be claiming.
Okay, gotcha.
Okay? Now that is only until the children graduate from high school. After the children graduate from high school, because they are adults, you will have to qualify to claim any of the child that you choose to claim after that. Because remember, they become adults, they get to decide whether or not they're claimed or not claimed.
Gotcha.
You guys need to inform yourselves on that, but it needs to be specific on there that until they graduate from high school, who will be the one to claim which child, okay? Okay. So Mr. Molina, you've heard the testimony by Ms. Molina. Is this also your understanding of your agreement?
That is correct. Yes.
Okay. Now, Ms. Molina, are you asking for a divorce today?
Yes.
Okay. Are you asking for a name change?
No.
Okay. Mr. Molina, are you asking the court to approve the agreement as testified to by Ms. Molina?
Yes, please.
Okay. And do you all feel that this is a fair and equitable distribution of your community assets, Ms. Molina?
Yes.
Mr. Molina?
Yes.
And do you all feel that this is an order that is in the best interest of your children, Ms. Molina?
Yes.
Mr. Molina?
Yes.
Okay. So I will pronounce you divorced today. However, this divorce will not be final until you submit your first amended agreed final decree of divorce with both of your signatures on it, and then I sign off on it. So just because you testified today does not mean that you all are divorced. You all understand that?
Yes.
We need like a meeting for that, Judge, or you just sign that one?
No. You will get it revised. You will have Ms. Molina sign off on it. You will sign off on it, and then you will refile it with the clerk's office.
Right.
Once it's filed, it'll get sent over to my office, and then they'll send it to my queue.
Okay.
Okay? But you're going to have until July the 9th to submit it.
Okay. You got it.
Okay? So if you do not submit it by July the 9th, then I'm going to set you for a hearing and ask you why it hasn't been submitted.
Sounds good.
Okay? Okay.
Yes,
Anything else?
No, Judge, not on my part. Thank you.
Okay. Ms. Molina, anything else?
No.
Okay. Then you're both excused.
Thank you.
Okay. Did we have anyone call in on number 3 on the court's docket? Okay. So let me call F1332-21-9 in the matter of the marriage of Jesus Delgado versus Palma Quintero. Both the parties are pro se. I had no one appear on this, so please set this for a drop docket.
Yes, ma'am.
Okay, did anyone appear call in for CL 21-1306-1? I?
No, ma'am.
Ana Sofia Armenta Casillas versus Jose Enrique Garcia was to be a hearing on a motion for substitute service. Let's set this for a status hearing then on July the 26th at 9:30. And that concludes this morning.